All right, good evening. Let's just get underway. It's Professor Guerra Pujol from University of Central Florida. We're going to do our lab number 3 out of 5 labs. Now, probably wondering, and if you're not, I'll pose the question right now. Why devote one of our 5 precious labs to what I'm calling the law of ideas or intellectual property rights? To answer this question, I want to show you a brief clip from an interview that Peter Thiel gave a few years ago when he was asked why was he the first person outside investor to invest in Facebook. And so let me show you that clip right now. I have it pulled up, and this clip, by the way, it's let's see if I did not close it accidentally. I thought I had it up. Oh yeah, here we go. Right, let me do a screen share. By the way, you may or may not know who Peter Thiel is. Among other things, right? He was really, I think, the only person in Silicon Valley in liberal, left-wing Northern California to come out and publicly say, hey, I'm going to support Donald J. Trump for president in 2016. If you don't believe me, look up on YouTube his address to the Republican National Convention of 2016, or better yet, he has a wonderful 10-minute address that he gave to the National Press Club in Washington, D.C., where he explains why he is, supporting Donald Trump. You may also know him as the guy who paid Hulk Hogan's legal bills when Hulk Hogan sued Gawker, this very popular media website, right, for invading his privacy, for posting some private video of his private life. This lawsuit, Hulk Hogan ended up winning, ended up bankrupting Gawker, and made Peter Thiel, if he wasn't already one, a villain in the eyes of many people. Also, Peter Thiel, you may know him. This is, after all, a course in the College of Business. He wrote a book called 0 to 1 about startups. In fact, I have the book right here in my library. It's a great book, by the way, if you want to start your own business. It's based on some lectures that he gave at Stanford on startups, and his book 0 to 1. You can see I even have it marked. It's a really good book. But what I want to show you here is this video clip where he explains why he invested in Facebook. First outside investor. And you have to understand, when Peter Thiel essentially gave Mark Zuckerberg $500,000, $500,000 in July of 2024, the Facebook, as it was called back then, had only been launched just a few months earlier in February at Harvard College. And so, how does someone give a college sophomore $500,000 for a website, Facebook? Today, we know, of course, it's called Meta. It's a conglomerate, multi-billion-dollar business. But at the time, Facebook didn't make any money. It wouldn't make any money until about 2008. So let me show you this film clip, and it'll answer the question why intellectual property rights are so important. Now, by the way, I want to apologize. This guy, Peter Thiel, whether you like him or don't like him, he comes across as a very smug, arrogant individual. You know what I mean? But what he's going to say in this lecture, in this short interview clip, it's going to be one of three of the most important ideas you'll learn, I think, in your entire 4 or 5 years at University of Central Florida, or if you're watching this video, some other college or in life, that you may learn overall. So let me go ahead and let me just pull that up. I have it pulled up now, and I'll show this to you.
How can you spot a winner as big as Zuckerberg?
Well, it probably would be somewhat misleading to say that all of this could be seen from the very beginning. I had looked at already a number of these different social networking sites, and there were definitely a lot of the early attributes were quite good. They seemed very competent technically, which was actually strangely not true of many of the other companies. But I think one of the other things to always I'm always very focused on at this point is not just the product or the abilities of the people, but sort of the third part is what I would describe as the business model, the business strategy. And I think that's often not given enough weight because inventing something new is generally good for the world. It doesn't mean that you automatically will do well as an inventor. In fact, most scientists and inventors end up capturing disturbingly little of the value you create. To succeed as an inventor or scientist or entrepreneur, you have to create X dollars of value for the world, and you have to capture Y% of X. And the one important detail people forget is that X and Y are completely independent variables, and that in most cases, Y equals 0%. And this is I think
That's certainly been my own experience.
Well, we're not we're not commenting on the magnitude of X either here, but we'll leave that unanswered.
I'm gonna pause. Did you just hear what Peter Thiel just said? I'm gonna put it to you in plain English because, like I said, it's full of a lot. Let me get my camera going, by the way. What he just said in plain English is this: it's not enough to have a good idea for a business, for a new product or a new service. What he calls the X variable. What is your idea? What do you want to do? You have to figure out a way of how that idea is going to make you some money. Because after all, why are you doing this? That's the Y variable. And like he says, the X and Y variables are independent variables. Nikola Tesla, perhaps one of the brightest minds of all time, died penniless. That's what he was referring to, by the way. Thomas Alva Edison, on the other hand, died, in today's terms, a billionaire. Why? Well, it comes down to what I call the law of ideas. Every single product or service or business model embodies a set of ideas. And what intellectual property law allows you to do is to literally own those ideas or own the expression of those ideas. I'll explain that distinction in a moment. But the broader point I want to make is that this is why I'm devoting an entire module, an entire class to intellectual property rights. It's a nice extension to where we last left off when we looked at the common law. We ended up with property rights in cases like Pearson v. Post and International News Service versus Associated Press. When can you own information? When can you own an idea? And if you own an idea, right, if that idea for a product or service becomes successful, then you can make money off that idea and protect that idea from potential infringers. So this is, frankly, if I only had one class to teach, if we only had one lab, this is what I would devote most of my time to. Because also intellectual property law allows us to see the main sources of law. You're going to see that intellectual property law really originates in the common law. There's also federal law protections of copyright, trademarks, and patents. And also, by the way, there's an international, the so-called GATT, General Agreement on Tariffs and Trades, that has an intellectual property component. So this is a great way of also doing international law. But I'm going to focus on the substance. What are intellectual property rights? How can you protect your ideas? So with that, what I want to do is, let's do this. For those of you watching my class live, I've put in the link, I put in the chat a link to the survey for this class. Those of you taking my class, that survey is your class participation points, your attendance for this class. So go ahead and do the survey. It's a graded survey, so you'll get full credit, whatever your responses are. Then I'll use the survey results to introduce you and provide you the big picture of the law of ideas. Let's go ahead and get some theme music in here. Give everybody just another 30 seconds. Take your time. I'll keep the survey open. By the way, that's got to be one of the best themes, game show themes of all time. Great. So the survey is in the link to the survey is in the chat. Again, if you're watching this live, let's go ahead and look at those survey results. I think I've got it over here. Great. I'm going to go. I'm going to refresh this so we get up-to-date statistics. Now, in the previous section, I had a little bit of a glitch getting these results because this is such a large class. Yeah, I'm getting the same glitch, so we're going to go ahead and do this again. It should say 100%. I apologize for the glitch. You know, when we have such a large class, you know, and I don't deal with the back end here. Yeah, this is we still got this problem. Try one more time. Last time, the third time was the charm. Okay, good. Now we have some survey results, and I still have one more section, but we should have most of the class. So 467 out of almost, I think we have, what, 696 students. So we got most of the class in here. We have a really nice sample size. So let's go ahead and look at these results. My first question is, have any of you created intellectual property or own intellectual property? Now, one way of owning intellectual property is by creating it. The other way is by licensing it from third parties, or the third way, right? You do what Zuckerberg did, just steal it from the Winklevi, you know, if those of you who saw the movie, The Social Network. But let's go ahead and check this out. By the way, these are the four main forms of intellectual property rights. We'll take a closer look at each one of these as the survey progresses. This is just a big picture, you know. What are the types of intellectual property? What are the ways that your ideas can be protected? You know, that why variable that Peter Thiel mentioned. By the way, recall we've got about 467 students who've completed the survey, and about 24 students have said that they own a copyrighted work. 14 said that they own a trademark, a mark of some sort. By the way, the word trademark is used indiscriminately to refer to both trademarks and service marks, you know, marks that distinguish goods and marks that distinguish services. I'll use the term trademark broadly. We have 2 respondents that they own a trade secret. A trade secret can be like a recipe. It can be, by the way, I have an example here of perhaps my favorite, perhaps the most famous, of course, trade secret, right, is going to be, I just drank my Mexican Coke. I do not do the high fructose corn syrup. Sorry about that. I'm doing Mexican Coke. I'm doing actual sugar. But of course, the Coca-Cola formula is perhaps the most famous of the trade secrets. My favorite trade secret is going to be the formula for Tabasco. You know, now this is a new product I bought. I didn't know Tabasco has an habanero or Scotch bonnet variety, but that's a great example of a trade secret. Trade secret can also be like a client list. You know, if you're developing possible leads, it can be you know, a business plan, anything, any idea that's commercially valuable that you take reasonable steps to protect, to keep secret, can be a trade secret. So we have a couple people there. Let's go back. Let's finish looking at our results. How many people have a patent? You know, we'll look at a patent in a moment. About one person, you know, 1 out of 400, you know, getting a patent we'll see is actually a very difficult, arduous task. And look at here, most of the people, 426, most of the class, 426 out of 467 respondents thus far say that they have not created any of these 4 forms of intellectual property. Well, I want you to take out your phone right now if you have it handy. And if you have an iPhone, for example, my wife got this for me. I was actually a BlackBerry guy, you know, before I met my wife. And if you go to your photo, right, and just look at the last picture I took was of my dog. That's intellectual property. You take a photo, that's an original work. Everybody in the class, you posted a profile pic in this class, you wrote a micro essay in this class, you wrote you were bored out of your mind in my last class and you did a little doodle, you took notes. Any original creation, it doesn't have to be good. There's no requirement that it has to be good. As long as it's original, the moment you create a work, the general rule is you own the copyright to that work. And by the way, here I'm testing, you know, did you do the reading? I think I took a picture of the, let me just double check here. I took a picture of, if you have the most recent edition of the textbook, page 783, you'll find it there where I talk about, you know, I wrote that chapter, by the way, you know, where I talk about intellectual property. And, you know, if you've taken a selfie, a picture, we all have created intellectual property, you know. And this takes me to my first point I want to make before we do the last 4 survey questions. Except for a patent, and even with a patent, you know, because that can be oftentimes protected as a trade secret, you don't have to register your idea or the expression of your idea to be the owner of that idea or the owner of the expression of that idea. You know, copyright law, marks, trademarks, trade secrets, all of this is common law, you know. Now, federal law does give you the option. You can apply for a patent, you know, if you have an invention. You can apply for a copyright, you know, copyright registration if you have an original work. You can also apply for a trademark. Well, the next question, we'll look at the ChatGPT trademark application. You know, you can apply. Why do companies like to register their intellectual property, whether it be a patent, a copyright, or a trademark? Well, there's 3 reasons why. I'll just be very general. One reason is if you do register your intellectual property, you know, whether it be a patent, a trademark, or a copyright, that registration is evidence, is dispositive proof as to who the true owner of the intellectual property is. You know, that's pretty powerful. You don't have to go around, okay, where's my evidence? You know, that I actually took this picture on this date. You know what I mean? The registration is going to be considered, you know, conclusive proof that that is the lawful owner of whatever is being registered. The other advantage is you get nationwide protection of your IP. You can go into any federal courthouse in the United States and enforce your ownership interest, your ownership rights, your IP rights, you know, whether it be a copyright, trademark, or a patent. And third of all, this is especially relevant in copyright, which is what probably most, if not everybody in the class owns copyrights, if you knew it or not. If you don't register and you own a mark or you own a trade secret or you own a, you know, a copyright, you created a copyright, you're only going to have protection really in that locality in which you created your mark or in which you're doing business, you know, if you have a mark. If you register your trademark, for example, you now get nationwide protection, as I mentioned, but now you can also get statutory damages. In other words, you know, normally when you try to enforce your property rights, you have to prove what your damages are. You have to prove what your losses are. Just because somebody stole your idea doesn't mean that you're going to get any money. You have to prove, actually, these are my economic losses. But if your mark or copyright, you know, is registered, the very fact that it's been infringed will trigger automatic, you know, statutory damages, money payments, compensation payments that are set out in the relevant federal laws, you know. And so all you have to prove is the how many acts of infringement there were, and multiply that by whatever the statutory formula is. And so, registration has some really powerful benefits if your ideas or expression of ideas are commercially valuable. Notice in my survey question, I didn't ask, have you created any commercially valuable ideas, right? That's what the market decides, right? I've only asked, have you created any ideas, And in fact, everybody has in one way. And I didn't ask, are they good ideas? Are they original ideas? I just asked, have you created ideas? And in fact, everybody has in one way or another. I mean, that's what's amazing. We all have the capacity to create intellectual property. All right, now with that, let's drill down and look at some specific examples of IP. And I want to start with, the theme of this course this semester is going to be Gen AI, or generative artificial intelligence, large language models. And it so happens that OpenAI, which is the company that launched ChatGPT 3.5, the one we've been using in this class, the free version, they also launched earlier this year GPT-4, which is the subscription version, which is even more powerful than the free version. And the free version is pretty good. We've seen it in this class multiple times. Well, just in July, just a couple months ago, OpenAI filed a trademark application for GPT-5. And I forgot to say, I should have done a preview of the survey. GPT actually stands for something, it's not an arbitrary or fanciful. It actually stands for Generative Pre-training Transformer, right? And I should have put here GPT, like Wikipedia. We could do this, and Wikipedia page. You can see that this is something that, is not exclusive to computer. Here we go. A Generative Pre-trained Transformer, right? It's just the general technology that OpenAI and other companies are using to produce these very powerful chatbots. And so the question is then, let me go back to the survey. Where is my survey? And by the way, I posted here also in the module. By the way, everything that I'm talking about in this class, if you're in my class, it's in the module. You can look at the ChatGPT trademark application for yourself. I double checked it this morning. It still hasn't been approved. You know what I mean? But I'm going to ask you, is this just generic or descriptive? In which case, it generally doesn't get any trademark protection. Trademarks have to be distinct. Or is this arbitrary, fanciful, or at least suggestive? And so what I've done is in this survey question, I've included an infographic to give you examples of the various types of categories of trademarks. The basic idea is that a trademark, to get protection, to be registered officially, or to be even protected at common law, there's two requirements. You have to be using it in commerce. You have to be selling or providing those goods and services, on the market, and it has to be distinct. Now, I will tell you one more point with federal, and this is all in the textbook, but with federal trademark registration, you are allowed to apply, register your mark as early as 6 months before you launch your product or service, to try to get that protection. You can't do it any earlier than that, but you do have a 180-day window in which, before you're ready to launch your product or service, you can start protecting your mark, But the general idea of trademarks is, trademark law is, you have to be in commerce. You have to be actually selling the Tabasco sauce. You know what I mean? Or like the Coca-Cola trademark, by the way. It's not just a trade secret, right? This is probably one of the most famous trademarks in the world, that beautiful Coca-Cola logo, right? There are even Coca-Cola stores that sell Coca-Cola merchandise that people are willing to buy. That's how beautiful and powerful this trademark is, right? But you have to be selling the goods, right? Or providing the goods or services in commerce, right? Now, if you have a new product, new service, you can apply up to 6 months early. And that's what this is telling me, right? If the ChatGPT GPT-5 trademark application was filed in July of this year, that means by the end of the year, January at the latest, they plan to launch GPT-5. But can they actually protect that mark? Let's see what the class thinks. And let's look at these results. What's amazing to me here, when you combine 13 and 14%, so about a quarter of the class thinks it's arbitrary or fanciful. But I'm going to tell you, I think that's wrong in the case of GPT-5, because arbitrary or fanciful, fanciful has to be, by the way, the best. Do you want me to show you the best example of a fanciful, Mark? There it is, right? Google. Right? Completely made up word. Here are some other examples that are very well known, like Pepsi and Kodak, Exxon and Clorox, complete made up words. Arbitrary. Arbitrary is simply something like a logo, a name that has nothing to do with the product being sold or provided. The Apple logo is the best example of this, and I've included Apple's trademark registration from 1979. It's amazing that, wow, over 40 years later, this logo still continues to captivate. By the way, this is one of the cool things of trademark law. As long as you're using your logo or your mark or whatever it is to sell products and services or provide them in commerce, you can renew your trademark registration every 10 years indefinitely, as long as you're in business, as long as you're actually providing or selling those goods and services. And of course, Apple has been in business all this time, and they're still using that same logo. I mean, trademarks I begin with trademarks because from a business perspective, I really, and in fact, in 0 to 1, the book I showed you earlier, even Peter Thiel says so. Like, you have to have a good idea for a product or service, but your marketing of that product or service is just as important as your idea, as the underlying idea, because that's how you build your brand. Why is your brand so important? Because that's how you not only attract customers, but you retain customer loyalty. Like when I go to a business, I'm trying to think of the last example, and they only have Pepsi products. Like I won't drink Pepsi, even though Pepsi really, it really, if you look at it objectively, it probably tastes better than Coca-Cola. You know what I'm saying? But I'm just a Coca-Cola guy, and a lot of places will only have Pepsi. And okay, sorry, then do you have beer? Because then I'd rather have a beer than before I drink Pepsi. You know what I mean? So to give you an example of like how powerful brands are, and you know what I'm talking about, like Tabasco. It's really not the best Tabasco. Probably, there's a whole Tapatio is way better if you think about it. But the brand, right? The Tabasco brand is so powerful, that I actually, ask for Tabasco, even though Tapatio sauce is probably better. Or those of you from Trinidad and Tobago will know about Matuks. There's even way better hot sauces out there, and I know there's a lot of others, from other parts of the world as well, but that brand is so important that people will have that loyalty. So that's why I'm beginning with trademark law. But the thing is, the brand has to be distinct. Let's finish looking at these results. On the other extreme, look at this: 21%, but 21%, 42% say this is either descriptive or generic, which get no trademark protection as a general rule. And notice the option that got the most votes is suggestive. If it's suggestive, it's considered distinct enough that the mark will receive trademark protection. Now, I will tell you a couple of interesting things. Look at these generic examples of generic marks: aspirin, escalator, shredded wheat, yo-yo. I could add the word Frisbee. I could add the word Kleenex. I could add, I would add Google. All of those, although Google, the courts have yet to decide whether it's generic. I've included a case involving Google in the textbook to make you want to read it. But all those other examples, shredded wheat, escalator, Kleenex, aspirin, all those were once registered trademarks. One of the interesting things about trademarks is that if your brand becomes so successful that that basically people use it, as a generic term to refer to all the products in that category, in that industry, you lose your trademark registration, which is kind of it's called, often it's called genericide. This is why the law is so important, because guess what? Let's say Google is generic, right? It doesn't matter if Google has copyrighted the logo. Okay, Microsoft can use Google, fine, but they can't use the copyrighted version of the Google logo. So what companies usually do is they will both trademark, use trademark law to protect you know, like the Coca-Cola, you know what I mean, brand, or the Tabasco brand, to give you two of my favorite personal favorite examples. But they will also use copyright law so that in case their brand becomes so successful that it converted to generic, they've also copyrighted their logo, you know what I mean? And that copyrighted part would still be protected. I'll give you a good example. I had a little Mickey Mouse, Minnie Mouse doll, I should say, but my dog just grabbed it. And so I don't have it now with me. It's a dog toy, but some of you may be aware that the Mickey Mouse copyright will finally expire, you know, on December 31st of this year. As I explained in the textbook, you know, Disney lobbied hard in 1998 to extend the life of a copyright, the copyright term, you know, for copyrights owned by business entity to up to 95 years. This was, in my opinion, an obscene, you know, totally awful extension of copyrights. You know what I mean? There's got to be a balance between the public domain and private copyrighted works, you know? But guess what? Even after the Mickey Mouse copyright expires in just a couple more months, guess what? Mickey Mouse is also a registered trademark, right? Because Disney uses Mickey Mouse to sell and market their Magic Kingdom, you know, and other things that they provide. So, you know, it's like, that's why copyright and trademark law can really work together to protect the expression of your ideas in the case of copyright law, or your brand identity, you know, the marketing of your products, of your underlying ideas via trademark law. All right, with that, let's jump. Now, by the way, with respect, by the way, one more thing, important lesson number 2. So lesson number 1 was Peter Thiel, right? It's not enough to have a good idea for a business, for a product or a service. You have to figure out a way how you're going to make money from your idea. And this is what intellectual property rights allow you to do. Idea number 2, that's really important. This is going to be the second most important idea. The law is not always black and white. What is GPT-5? I think it's, personally, my opinion, I think it's generic. I think GPT, all that stands for is generative pre-trained transformer, and the 5 is just telling me it's the 5th iteration of the ChatGPT model, you know? So that's, to me, that's totally generic. You know, hopefully OpenAI, you know, from their point of view, have copyrighted their logo. I personally don't think they're going to get a trademark registration. But it might also be descriptive, right? That GPT-5 really refers to the OpenAI version of the chatbot, you know, and in that case, courts have ruled, you know, applying the federal trademark law, that if your mark, even if it's merely descriptive, if it has a secondary meaning, and I'll show you an example, it's on my survey. Let me show it to you, those examples. KFC or the Weather Channel are great examples. The Weather Channel, what could be more descriptive? I would even say generic than that. Kentucky Fried Chicken, that actually sounds even generic. Southwest Airlines, right? To describe an airline that's a regional airline for, you know, the southwestern states. But guess what? When consumers hear the Weather Channel, they're really thinking of the one and only Weather Channel on cable TV, right? When consumers hear KFC and see that logo, they're really thinking of the Colonel Sanders, right? When consumers hear Southwest, they're really thinking of not a generic airline, but the Southwest airline that now serves even above and beyond the Southwest, you know? And of course, you might say the same thing about GPT-5. Maybe there's a secondary meaning, you know, just because of how popular that chatbot is. So it might still get protected. By the way, maybe it's even suggestive. We don't have to talk about secondary meaning. But my larger point here, before we do the last couple of questions, is that notice it's not black and white. You have to apply the law to the facts, right? And there's always an element of interpretation there. So it's not clear whether GPT-5 can, in fact, be successfully registered as a trademark, or whether the trademark office is going to go ahead and reject that, you know, out of hand as being either generic or descriptive with no secondary meaning. That remains to be seen. That's why I wanted to show you a real-time trademark application filed just a few weeks ago. So you can see that when we're talking about the legal environment, there's a probabilistic element to it. All right, my next question has to do with trademarks and trade secrets, and it has to do with what I think is the most important idea, probably, I mean, at least until OpenAI came out with ChatGPT, right? The PageRank algorithm, right? The Google search engine. I can go into Google right now and put pizza. Look, it'll fill out for me pizza near me, or pizza Orlando, or pizza Winter Park where I'm at right now. And look what it does. Boom, it gives me a map with a bunch of pizzerias here in red. It's going to give me, I can go, the old Google, right, would just give me a bunch of links, the original Google. But now look what I get. Look how cool this is. By the way, I'm going to allow this. Now also the new Google, the Google we have now, I can go into images and it'll give me a bunch of pizzas. I can go into news, maybe there's maybe there's some pizza reviews, or maybe there's some scandal involving, a health hazard or something with one of these places. I can go into all of these things, you know what I mean? Other books about pizza, you know what I mean? Whereas the original Google would only give me the 10 links. So how does Google protect what is probably, up until OpenAI's ChatGPT, the most valuable intellectual property we've ever seen? What does the class think here? And by the way, here I've given you a little primer, it's all in the textbook. What are the comparisons and differences, comparing and contrasting patent law and trade secret law. Both areas of IP law protect your actual ideas. Trademarks and copyrights protect the expression of your ideas or your brands. Here, we're talking about actually protecting what your ideas you may have, and so what does Google do? And it's interesting here, we have a 60-50 split, 60-40 split. And let me tell you here, you're both right. I'm going to show you the original patent filing, patent application, the original patent for the PageRank algorithm. But let me just tell you right now, actually, let me show it to you right now. Why talk about it when I can show it to you? I have it right. I have it pulled up. By the way, all this stuff is in the module. If you want to take a closer look at this patent. It already expired. It already expired, you all. You know what I mean? This is why Google uses a combination. They have thousands of patents, but they also use California trade secret law in order to protect their valuable, ideas. So a lot of the innovations that I showed you with Google search before, when you did Google search, like back when I was using it, back when it started, you would get these 10 links, but now when you go to Google search, right, you can get images, you can get books, you get maps, now you get the reviews, you know what I mean? You get a whole bunch of stuff in addition to the links, so, and a lot of those innovations, Google is using trade secret law, just regular common law, trade secret, there's no registration, they just have to keep the idea a secret. Now, normally, let me tell you here, with trade secret law, you do run trade secret law has a great advantage. There's no registration, no expensive filing, nothing like that. But you can't, and it's indefinite, as long as you keep your idea a secret, you can protect your trade secret indefinitely. But the rub is reverse engineering is a perfect defense to trades, to a trade secret lawsuit. So if I can figure out a way to make the Tabasco sauce myself, you know what I mean? Just the other day, a neighbor of mine gave me a bag of peppers because she has so many pepper plants. So she shared some peppers with me. Hey, I'm not going to say no to peppers because I love peppers, right? If I can figure out a way of making those peppers just as good as the Tabasco, hey, that's perfectly legal. You know what I mean? If I can figure it out on my own. If I can figure out how to, create the PageRank algorithm on my, all those innovations, that's perfectly legal, So that's the trade-off. With patents, I get a 20-year exclusive monopoly, you know what I mean? And I can, and that does protect me against reverse engineering, but it's going to expire after 20 years. Like the Google patent has already expired, right? Expired over 2 years ago. Whereas trade secret law, I get indefinite protection and there's no expensive filing procedure, but I do, I can run the risk that somebody can reverse engineer my idea, my product, my service. Now, I want to say one more thing about this before I forget, and that is the Google patent. Let me show you one more aspect of the Google patent, just to show you how hard it is to get a patent. Look at when the patent was filed. Do you see that? Let me make this. I want to make sure everybody sees this. This patent was filed by Larry Page. You see him up there, January 9th, 1998. Did you notice it wasn't approved until September 4th, 2001? In other words, it took, what turned out to be probably the single most valuable idea in the history of capitalism. Google right now, its market, Alphabet Inc., its market capitalization is $1.6 trillion. Google is worth more than the entire economy of Brazil, which is about a 1.5 trillion GDP. I mean, that is remarkable that Google is worth more than the largest country in the Western Hemisphere. That to me is just blows my mind. You know what I mean? It took Larry Page almost 4 years, 3 years, 7 months, and 27 days to be precise, to get this patent, of what would turn out to be probably the best idea of all time until OpenAI came out, with ChatGPT. And why? Getting a patent is really hard. And the reason why is to get a patent, it's not enough that your idea be commercially valuable. You have to show that your idea is novel. No one else has come up with it. It's useful. It solves a real world problem. And most difficult requirement, the third and most difficult requirement to get a patent, is you have to show that your invention was non-obvious. I'm talking here about utility patents, about inventions. Think about it. What that means in plain English is you have to show you're Larry Page. It's 1998. There's already, AOL has a rudimentary search engine, right? Yahoo has a search engine. There's this thing called Alta Vista. There's this other website called Ask Jeeves. These are all primitive search engines. You have to prove that given the state of scientific knowledge at the time that you apply for your patent, your idea was non-obvious. That is to say, in plain English, nobody else, no other inventor, no other company, no other mind would have come up with that idea, given the state of existing technology and knowledge at the time. Okay, well, how the hell did Larry Page come up with the PageRank algorithm if his idea was so non-obvious? It's really, really tough, and as someone who has worked with patent law and has, as a patent lawyer, I can tell you right now, the patent office, their protocol is basically, we're just going to deny. Anybody comes in, we're going to deny. We're going to force you to prove that your idea is non-obvious, in addition to being novel and useful. And how do you prove? That's a pickle. That is a paradox. How do you prove something is non-obvious when you yourself came up with it, right? And so it took even Larry effing Page, the co-founder of Google, it took him almost 4 years to get a patent. So you can see why that even Google, one of the most powerful, successful companies, I'm not saying that they're not evil, but I'm saying one of the most powerful, successful companies in the history of capitalism, even Larry Page, it took him almost 4 years to get that idea approved. That's why trade secret law, right? You don't have to get permission from anybody. All you have to do is, have a commercially valuable idea. That is to say, an idea that other people would want to steal if they could, but you've taken reasonable steps to keep that idea a secret. Now, by the way, in the module, I have a little bonus section about, did Mark Zuckerberg steal the idea, for the Facebook? And let's be honest, he did steal the idea. There's 100%, he could sue me for libel, defamation, whatever he wants. He stole the idea for Facebook, but that's not the same as saying, did he commit theft of the trade secret, misappropriation of the trade secret, to use the technical term? Because here's the problem, right? The Winklevoss twins shared their idea with Mark Zuckerberg, and under trade secret law, you're required to take reasonable steps to keep your idea a secret. So what big companies like Google do and smart startups do that hire experienced IP lawyers, what they'll do is they'll try to get their employees and prospective investors and others, before they share that idea, to sign a non-disclosure agreement. Or if it's an employee, make sure you have a bulletproof confidentiality clause in that employment agreement. Now, because this is all common law, it's going to be minor variations and sometimes major variations among the 50 states. You know what I mean? And so you always have to consult with a licensed attorney in the state in which you're operating, right? To make sure that your confidentiality clauses and your non-disclosure agreements are bulletproof from the perspective of how the common law has developed in your state, in your jurisdiction, in your locality. I just want to throw that out there, you know, but that's why companies use not just patents, but also trade secrets, even powerful companies like Google. All right, let's finish up. I have two miscellaneous questions. One is, can you copyright a tattoo? And I just want to throw that out there because I'm a huge, huge Mike Tyson fan. I want to share with you, this is the most important lesson. If Peter Thiel was the third most important lesson, you know, X and Y are independent variables. You have to have a good idea for a business, but you have to figure out how you're going to make money from the business. If the law is not black and white all the times, you know, there's an area of discretion. A lot of it involves some kind of predicting what courts will do in the future. That was the second most important idea. I'm going to use this tattoo question, Mike Tyson, to share with you the most important idea of this class. And then I'm going to end up with OpenAI, a question about OpenAI in a current lawsuit that was just filed a few days ago, so that I can set the stage as a preview for my next class, which is going to be about, you know, criminal and civil litigation. So let's go to that next to last question. And this is my favorite quote. This is my favorite Mike Tyson quote. Everybody has a plan until they get punched in the mouth. I mean, let that sink in. Everybody has a plan until they get punched in the mouth. Anybody in the class have a BlackBerry? You know? Anybody in the class have a BlackBerry? BlackBerry got punched in the mouth. They had for almost a 50% market share in 2007 when the iPhone was launched, in a very competitive smartphone market. BlackBerry was the most expensive phone at the time, smartphone at the time, and yet they had almost 50% of the market. You know what the BlackBerry market share is today? It's basically zero. You know, they were punched in the mouth by Apple when the iPhone came out. I'm going to be honest with you. I was a BlackBerry user. I like having my keyboard there, you know, and they got punched in the mouth. And, you know, my wife gave me this iPhone, this old iPhone, and I'm still using it. You know what I mean? Amazing. You know, anybody been to Blockbuster Video lately? Right? Did you know that Blockbuster Video, you know, next to McDonald's, was the largest franchise chain in all of the world? You know how many Blockbusters are left? There's actually one. There's actually one, at least last I checked. You know what I mean? In Oregon, and it's mostly a tourist attraction that people go, "Ah, this is the last Blockbuster Video." You know what I mean? That's insane. They were Blockbuster was punched in the mouth when Netflix came out. I could go on and on and on. I could give you examples, but the reason why I love this quote and the reason why I put Mike Tyson quote as the number one lesson you're going to learn in this class, maybe even in college, is because I'll speak from experience. You know, I'm going to speak from experience. I've suffered some, you know, I'm an academic, so I don't do business and stuff like that. You know, I like writing papers. I like thinking. I like teaching. But I've suffered some really bad setbacks in my personal life. You know, I have lost loved ones. You know what I mean? Just last month, I lost a very close friend of mine. You know what I mean? I've had setbacks in personal relationships, really tough stuff. You know what I mean? I've been betrayed. I've had setbacks. I've had major failures, even in my academic, you know, all over. You know what I mean? But guess what? Everybody has a plan until you get punched in the mouth. I think what Mike Tyson is trying to tell us here is that you have to have a plan, right? You got to, but more important than your plan is you have to be able to adapt and respond to setbacks and come up with a new plan when things don't go your way, you know? And that, to me, I think that is like, I put Mike Tyson on the level of Aristotle. That is like some mind-blowing information right there. Now, I want to ask about tattoos because, I said most, almost all original works are protected under copyright law, but there's an interesting historical exception that goes back to the common law, and that is articles of fashion. So in this survey question, and by the way, you may recall some years ago when The Hangover Part 2 came out, the Mike Tyson's tattoo artist who gave him that Maori inspired tattoo, he sued Warner Brothers, the studio, for basically, putting on one of their Hangover characters, the Stu character, Ed Helms, a very beloved actor, you know what I mean, for having a similar tattoo, and that he wakes up in Bangkok, some crazy night, and then boom, I have a Mike Tyson tattoo all over my face. Is that copyright infringement? Well, it depends. Again, the law is not black and white. It's going to depend. Is a tattoo more like a work of art? Some people actually call tattoos body art. I did some research on this. Fascinating. Actually, a student of mine back in 2008, before even the Mike Tyson case, who brought this tattoo problem to my attention. I have all this stuff in the module. Or is a tattoo because it's on your skin, it's on your face, it's on your, it's on your, it's on your arms. Maybe, maybe it's on a private part. I don't know. Is it more like an article of fashion? Articles of fashion cannot be copyrighted. So like a tie, I'm wearing my UCF tie. Anybody can make a tie like this with this pattern. Now it's true, right? UCF has their registered UCF trademark, right? So only UCF can sell a tie with the UCF logo, right? Or whoever. And actually, the reality is what UCF does is they license the rights to the UCF. There's a third company that has purchased the rights to use the UCF logo to make this tie. But my point is anybody can make a tie. You know what I mean? And so what is it? Let's see what the class thinks. And by the so let's go to the survey results, and then we'll do the last question and then end this lecture. Look at this, what we have here. Almost a 1/3, 2/3 split. 1/3 says, yeah, no, tattoos, they're like works of art, of course. You know what I mean? But 2/3 of the class say, no, in my opinion, this is kind of like a fashion accessory. And so it won't get protected. Now, Google this. What is the average age of a federal appellate judge? I already Googled it and I double checked it. It's 69 years old. I want to teach you a larger lesson about the legal environment of business. If you're suing someone, and your argument is that a tattoo is a copyrighted, is a work that's eligible for copyright protection, do you really want a 69-year-old judge deciding this case? You know what I mean? Think about who judges are, regardless of their age. Remember, that's the average age. So half the judges are older than 69, But even if the judge is younger than 69, think about who judges are, right? These guys and women, they're straight arrows, right? These, if a federal judge, they're appointed by the president of the United States and confirmed by the United States Senate, right? These are very, being a judge is considered a pinnacle of a legal career. That's why these guys are, and women tend to be older. It's a pinnacle of a legal career. They tend to be, even if they're politically liberal, maybe they're appointed by Obama or by Biden, they are culturally conservative. They're straight arrows. They're, they're white lace, shoelace. You know what I mean? It's, because they're judges. You know what I mean? They probably haven't done that many crazy things. And so that we know about, right? So it's kind of interesting. Is that going to affect their decision when they have to decide as a matter of law? Is a tattoo more like a work of art or more like a fashion accessory? Well, I would just say, of course, it's going to affect their decision, but in which direction, I don't know, right? And so this is why, by the way, in fact, all of these cases alleging that, or claiming that tattoos should be protected as a copyright, they've all been, including the Mike Tyson case, they've all been settled out of court. No one has wanted to take their chances with the judge, with the jury on this, you know what I mean? And the Supreme Court of the United States has yet to decide this question, and so we'll see what happens. I've included if you're really into this subject as I am, I've included a single-spaced 49-page law review article with like hundreds of footnotes that surveys this area of law, and it's super fascinating. Totally optional, just for those of you going to law school. this is what, this is the stuff that you'll be reading and studying, give you some idea there. All right, let's do our last survey question and wrap up tonight's class. The last survey question, I want to go back to OpenAI because just a few weeks ago, these top best-selling authors like George Martin, this is the guy who came up with Game of Thrones, right? This is HBO Max. That's just their top show, most popular show of all time. John Grisham, best-selling novelist about lawyers and law firms and corruption. Many of his books have been converted into movies with, Tom Cruise, A-list actors and actresses. Just Jodi Picoult, just the top best-selling romance novelist. She actually outsold both John Grisham and Martin combined. All of these individuals got together and brought, just a few days ago, I've included this in the module, you can see it for yourself. They sued ChatGPT for copyright infringement because the idea is ChatGPT, remember, it's a generative pre-trained transformer. Pre-trained, it needs data for it to work. And the truth is, all of that data, it basically, I don't want to say stole, I want to prejudge the question. I don't know if OpenAI is going to win the case or lose the case. But if I could just speak like street level, they basically, stole or borrowed all of that information from the internet. Like if somebody ever posted any of John Grisham's PDF of that novel, any of his novels on the internet, or if anybody posted an episode, even illegally on the internet, all of that stuff has been sucked up by the ChatGPT, by the actual GPT, all of that information. And so these authors are saying, wait a minute, we spent lifetimes creating these works. We ran the risk. We were successful. And now ChatGPT comes and basically steals all all of our literary works so that they can train their algorithm to provide, these very realistic answers. You know what I mean? Like you can ask ChatGPT, I'm not going to do it now for lack of time, but you can ask OpenAI, answer this essay for me in the voice of John Grisham. Answer this essay for me in the voice of Jodi Picoult. Answer this essay as if it were a Game of Thrones episode. You can do all of that. You know what I mean? And ChatGPT, when you own a copyright, you own who gets to copy your intellectual property rights. That's why it's called a copyright. You own what's called all of the derivative works of your original copyright. But here's the interesting thing. I'm about to show it to you. It's in this survey question. And let's call this the fourth most important idea I'm going to teach you this class. I personally think property rights is the most important right of all of the rights. I think it's more important than free speech. I think it's more important. I think it's super important. But no, it's super important. It's just as important as free speech and these other rights. But guess what? No rights are absolute. Just like you can't yell fire in a crowded theater, you don't have those free speech rights, don't go that far. Even property rights are not absolute, right? And so the idea is when courts, like Napster was shut down because the courts declared that what Napster was doing was allowing users to share copyrighted files. Now this raises an interesting question. That's the question of the survey. I can't wait to see these results. What about YouTube? What about YouTube? The only difference between Napster and YouTube is that with Napster, users were sharing MP3 files, audio files of music. With YouTube, users are sharing MP4 files, video files. Well, I'm going to tell you what the main difference is, and this is super important. It's in the textbook. It's called the DMCA. I consider this the most important aspect of not just copyright law, but intellectual property law. And let me explain why. What the DMCA does two things. It's called the Digital Millennium Copyright Act. And what it does is, and by the way, this act has an amazing history. When President Bill Clinton was impeached for lying about not having sexual relations with Monica Lewinsky, and before his impeachment went to trial in the Senate, the House, both the House and the Senate approved the DMCA in October of '98. President Clinton signed it into law, in spite of the fact that there was a major constitutional crisis going on at the time. What the DMCA does that's so important, it does two things. First of all, it says the Congress is going to extend copyright law and by extension, all IP law to the internet. You know, back in 1998, you have to understand the internet was about, 1,500 days old. The internet was really just barely, commercial internet where anybody could access it, it was basically pretty new. And so the idea was that the internet was going to be libertarian. They're going to be, no laws, no taxes, no restrictions. People could do and share, would do whatever they want. Of course, now, when was the last time you bought something on Amazon? You probably paid sales tax, if I'm not mistaken, right? There are a bunch of laws that apply to the internet now, right? So, and among these are going to be the DMCA. What the DMCA does is, but it's interesting. It strikes a compromise. If somebody does post, it says, okay, first of all, it says, okay, we're going to go hardcore. The internet is no longer a libertarian utopia. The internet is going to be regulated. Intellectual property rights are going to apply to the internet. Sharing copyrighted files is going to be a violation of the copyright, copyright infringement. But it's interesting. If you own copyrighted materials, if you're a big record label or a movie studio or a publishing house, you first have to send a takedown notice to the infringer and give them a reasonable opportunity to stop infringing, to take down the infringing materials. Well, this explains the difference between YouTube and Napster. Napster ignored the takedown notice it received from Dr. Dre, from Metallica, and then later from the Recording Industry Association of America. Metallica gave a big middle finger to the copyright owners. YouTube, on the other hand, I'm sure it's happened to you. Try finding your favorite Prince song on internet, on YouTube. You're not going to find it. It's all been taken down because, Prince's estate is aggressively, enforcing their intellectual property. To me, by the way, that's mistaken, the point here is that YouTube actually complies with the takedown notices. So let's see what the class thinks. By the way, this is going to go to court, right? Is ChatGPT the next Napster? Is it going to get shut down? Or fair use? Is ChatGPT transformative? It's interesting that GPT actually stands for generative pre-trained transformers, or if I can show you that original image, you know what I mean? But courts, to decide something is transformative, they have to apply these 4 factors, and I explain this more in the textbook. I'm not going to get into it now, but this is going to be OpenAI's defense. Do you think, and again, this is the larger point I want to make before I conclude, the law, ownership is not absolute. That's why I haven't once used the term internet pirate or internet piracy once, except to now critique that term. Because to say someone is an internet pirate prejudges the question of whether it's fair use or not. That's why I hate that term. And I hate all of those fake FBI notices that you're subject to civil and criminal liability if you copy, a CD or something like that. You know what I mean? Yeah, it's true. You could be subject to criminal or civil liability, but that's prejudging whether this is fair use or not. But here's the rub. The court's determining whether this is fair use. So what if this goes to court? What does the class think? Is OpenAI going to prevail on a fair use defense? Or, hey, this is basically Napster. OpenAI basically, they didn't borrow all this information. They stole it to perfect their algorithm. Let's see. I want to see what the class thinks on this. Because your guess is as good as mine, right? This case was just filed. And look what we have here. 20% says that this is going to be the next Napster. 50% says, no, OpenAI, this is good. They're going to win. This is transformative. This is fair use. But look at this. Almost a third, 28% say the parties will settle out of court. This is exactly what I'm going to talk about. It's the preview of my next class. Think about it if you're OpenAI. Are you really going to go to a judge or a jury if there's a 20% chance that your whole business model will be declared illegal like Napster's was? Wouldn't you rather settle out of court, pay something to get these guys to drop this threat? Or wait a minute, if I settle, all these other people are going to sue me now, and I'm going to have to pay everybody. No, I'm going to fight this. I'm going to be like, I'm going to fight this. and we're going to fight this to the end. You know, like Winston Churchill, we're going to fight in the sea, we're going to fight in the air, we're going to fight in the land, we're going to fight wherever we have to fight. Well, we'll talk about that in the next class, because when we talk about civil and criminal litigation, 2 weeks from today, for those of you enrolled in the class, because that is the most critical question when it comes to business litigation, either civil or criminal. Do you settle out of court or plea bargain if it's criminal, or do you take your chances with the judge or jury? We'll see that question in more detail in the next class. With that, class is now over. I'll stay on for a few extra minutes if anybody has any questions, comments, or concerns about any aspects of the course. Otherwise, good night, God bless, and charge on.
Thank you, Professor. Good night.
Good night. Thank you.
Have a good night.
Good night. Thank you.